Hey there, I'm estate planning attorney Paul Rabley, and in this video I'm going to talk about the recent announcements and changes to the federal estate and gift tax law. So the IRS recently announced that the annual gift tax exclusion would remain at $19,000 in 2026. It was $19,000 in 2025. I think it was $18,000 in 2024. It gets adjusted periodically for inflation, but it's going to remain at $19,000 for the calendar year 2026. What that means is an individual can donate or give $19,000 to as many individuals as they want to without any federal gift tax consequences. Now, let me describe what federal gift tax consequences mean, because there's a lot of misconceptions out there. Some people mistakenly believe that if they make a gift to someone in excess of this $19,000 annual exclusion amount, some people mistakenly believe that if a gift is made that exceeds $19,000 in a calendar year, then somebody's going to owe some tax. And that's not necessarily true, because we have an estate tax and a gift tax. They're unified. Might as well touch on the estate tax now. The estate tax for exemption, or as it's commonly referred to as the basic exclusion amount, the estate tax exemption for 2025 was $13.99 million, but for 2026, it's going to be $15 million, and then it will be adjusted for inflation every year thereafter. So in 2026, we'll have a $15 million estate tax exemption amount or basic exclusion amount, and we'll have a $19,000 present interest annual exclusion gift amount. So what that means is, let me give you an example. Let's say dad writes a check in 2026 for $119,000, and he writes that check. He wants to give some money to his daughter, and she wants to buy a home. Really doesn't matter what she does with it, but he makes a gift to her of $119,000. Now, the question is, who owes tax, and does anybody need to do anything? So the answer is, assuming dad made no other gifts to his daughter during 2026 other than the $119,000 check that he wrote her. Well, the way that works from a math standpoint is the first $19,000 of that gift, well, it's gift tax free, because he can give $19,000 to as many people as he wants to every year, but he gave her $119,000. So on that excess $100,000, nobody owes any tax. What it means is dad just used $100,000 of his, for 2026, $15 million estate tax exemption or basic exclusion amount. So what that means is, if dad makes no other gifts and he dies at the end of the year in 2026, or dies in let's say in late 2026, well, then he can only leave $14.9 million free of the federal estate tax, because by making a gift of $119,000, he used $100,000 of his basic exclusion amount. So when he dies, he doesn't have $15 million of his exclusion amount remaining. He only has $14.9 million, which probably he's never going to use any of that anyway. So that's a lot of talk for which means for most people, they can make gifts regardless of their value, and nobody's going to owe any tax. Now, if he did make a gift of about $119,000 to his daughter, he is required to file a gift tax return. It's called IRS Form 709, a federal gift tax return, and show the IRS that he used some of his basic exclusion amount, but still there's not going to be any tax due with the filing of that return. A couple of other points. Married couples often make gifts to their children. So married couples, each spouse can give $19,000 to as many people as they want to. So we see a lot of the really wealthy people who will be subject to estate tax when they die. We see those married couples often, make gifts of $38,000 a year to each of their children, perhaps to each of their grandchildren. Sometimes those gifts are put in trust, because the parents and grandparents don't just want to write a check to those children and grandchildren, give it to them in a lump sum. So there's special requirements necessary when you make gifts to a trust for your children and grandchildren to make sure those gifts qualify for what's called the $19,000 present interest annual exclusion. Some people make mistakes, and by putting gifts in a trust for children and grandchildren, The mistake that people make is they give those descendants a future interest in the money, and it doesn't qualify for the present interest annual exclusion. So I've made some other videos about that. Another key point here is for married couples, each spouse has a $15 million estate tax exclusion amount. So if you use them properly and have the right estate planning documents, and it's not too hard, but with a little thought and a little planning, married couples really get to shield $30 million from the 40% federal estate tax. So as the years go on, fewer and fewer people are subject to the estate tax. I can remember back when I started working in this estate planning field decades ago, the estate tax exemption was only $600,000. Now it's $15 million. Fewer people are subject to it. So that's what's up lately with the federal estate and gift tax. Hope that helps. We'll see you next time.